Hello and welcome to the second video in our project by the International Insolvency Institute Committee, Model Laws at Work. In the second video in a series following the MLCBI video, where the key rules and sections of the MLCBI are explained, we look at the experience of four jurisdictions, Bahrain, Brazil, Greece, and Singapore, in their adoption and application of the MLCBI. I am Sheila Ng from Singapore, and with me are Judge Fatima Hubil from Bahrain, Guilherme França, and Sabrina Bacchi from Brazil, and Yanis Bazinas from Greece.
The MLCBI is an important topic, one which is being taught as a key topic in the insolvency subject. It has been regarded as a successful instrument and a helpful tool to draft legislation since 1997. On the four jurisdictions represented in this video, Brazil has adopted the MLCBI most recently in 2021, and Greece had adopted the MLCBI in 2010. Yanis, until today, Greece is one of the very few EU countries that have enacted the MLCBI, the others being Romania, Slovenia, and Poland. Can you share with us the background to Greece's adoption of the MLCBI?
Well, until the introduction of the MLCBI back in 2010, there was no clear framework for the recognition of foreign insolvency proceedings in Greece that originated outside the European Union. This issue was generally approached through reliance on traditional rules on judgment recognition, but these rules were unable to provide some much needed clarity on the standing as well as the powers of the foreign insolvency practitioner in Greece, as well as the effect of the recognition of foreign insolvency proceedings on potential creditor enforcement actions in Greece. Now, these issues were specifically flagged by a legislative committee that was formed to consider the implementation of the MLCBI in Greece. At that point, the Greek legal framework lacked any appropriate mechanism to deal with cross-border cases outside the EU context, and the new insolvency code that had just been introduced in 2007 lacked any provisions in that issue. In that context, the purpose of the MLCBI's enactment was to provide the Greek legal framework with a modern and comprehensive regime for managing cross-border insolvencies. And in fact, one of the stated objectives that was particularly highlighted by the committee was the need to address the risk of asset concealment and to provide mechanisms to ensure that fraudulent debtors could not put their assets beyond the reach of their creditors. When it comes down to looking at the Greek enactment and its mechanics, the MLCBI was adopted almost verbatim. The main driver of this approach was the need to maintain uniformity with other jurisdictions in order to enhance cooperation in cross-border insolvency matters. As a result, the main pillars of the MLCBI, access, recognition, relief, and cooperation, are retained and incorporated into domestic legislation without any further trouble. And these four main pillars are explained in the MLCBI video, the first video in this series. As a general matter, the Greek version of the MLCBI is a very comprehensive framework that closely tracks the provisions of the original MLCBI without many divergences. In general, because of that reason, the introduction of the MLCBI did not really involve any conceptual or high-level debate about its overarching principles, but was merely viewed as a step in addressing practical issues in the cross-border context. And one important issue that we have to understand about how the MLCBI was enacted and interacts in Greece is to consider how Greece was well positioned to enact the MLCBI framework. Since Greece is an EU member state, cross-border insolvency matters that implicate other EU member states, such as the question of recognition of foreign insolvency proceedings originating in other EU jurisdictions, were already being regulated by the European Insolvency Regulation, the successor of which continues to govern to this date. In that sense, the experience that had already been gathered in the context of the EU framework meant that courts, practitioners, lawyers, judges could easily conceptualize and understand the challenges associated with cross-border insolvency, and were already familiar with some of the main and important concepts underpinning the MLCBI, such as COMI, main, non-main proceedings, and the like. These concepts are also explained in the first video of the series. As a result, the introduction of the MLCBI did not require any particular familiarization of the Greek courts and practitioners with its provisions and underlying logic. Overall, then, the Greek experience with implementing the MLCBI has to be viewed in perspective of the parallel application of the European insolvency regulation. And unsurprisingly, the vast majority of inbound as well as outbound cross-border insolvency cases involve other EU member states, and thus involve the application of the regulation and not the Greek enactment of the MLCBI. That being said, though, there have been a handful of cases that have applied the MLCBI, and in their majority, these cases either involve recognition of personal bankruptcies of foreign nationals, the vast majority of which are Greek expatriates in the US or other jurisdictions, non-European jurisdictions, and the recognition of these bankruptcies over assets, usually real estate in Greece, or alternatively, insolvencies of offshore shipping companies, which operate or are managed through a branch in Greece, although in these cases, there are usually not that many assets to be found in Greece.
Thanks, Yanis. On the other hand, there are jurisdictions without any existing formal cross-border insolvency framework in place before the adoption of the MLCBI, such as Bahrain. Judge Fatima, could you share with us the factors Bahrain had taken into consideration when adopting the model law?
Bahrain actually is a small island in the Arabian Gulf. With its central location and safe, welcoming environment, the Kingdom of Bahrain has become a thriving hub for businesses from all over the world, and welcoming investors from all over the world. With that, it was of paramount importance to the kingdom to develop and enhance its international practices, and especially when it comes to bankruptcy cases that has a foreign element. So prior to 2018, the 1987 Bankruptcy and Composition Law was in force. It continued to govern bankruptcies up until 2018 without any amendments to its rules. That law, as good as it was, still lacked some when we say interactions with the international community. And it lacks some proper tools to deal with the bankruptcies that has foreign elements and complex reorganizations. So with these things in mind, the legislator strived to develop a bankruptcy law that is efficient, comprehensive, modern, globally familiar, and capable of dealing with modern issues. And that provide effective mechanisms for dealing with cases of cross-border insolvency. So to promote, according to its articles, the objectives of cooperation between courts and other competent authorities in the kingdom and foreign states involved in cases of cross-border bankruptcy. Enhance and to have a greater legal certainty for trade and investment, fair and efficient administration of cross-border insolvencies that protects the interests of all creditors and other interested parties, including the debtor, protection and maximization of the value of the debtor's asset, and facilitation of the rescue of financially troubled businesses, therefore protecting investment and preserving employment. Thus, Bahrain's reorganization and bankruptcy law of 2018 was drafted according to the UNSTRA legislative guidelines, and its Chapter 5 on cross-border insolvency was heavily influenced by the MLCBI. On cross-border insolvency, if it's not based on its entirety on that model law. Bahrain had carved out certain entities from the application of Chapter 5 of the law on cross-border insolvency. For example, it does not apply to insolvent licensees of the Central Bank of Bahrain and those that are subject to the Central Bank of Bahrain, such as the financial institutions here. The insolvencies of these institutions, such as banks, stock trading companies, and insurance companies, etc., are governed by other laws in the kingdom. And when it comes to international obligations of the kingdom, it is worth mentioning that in the event of a conflict between the previous provisions of Chapter 5 of the law on cross-border insolvency with the obligations of the kingdom arising out of any treaty and other forms of agreement to which it is party with one other state, the requirements of that treaty and that agreement shall prevail. Thank you.
We see that in Greece, the adoption of the MLCBI was motivated in particular by the desire to address the risk of asset concealment, whereas in Bahrain, it was to create a framework to facilitate international trade and investments. Guilherme, turning to Brazil, what was the driver behind the adoption of the MLCBI?
So Brazil implemented the MLCBI by amending the Brazilian federal law that covers enterprise insolvency matters. As you mentioned, this law took effect on January of the year of 2021, altering multiple provisions of the Brazilian Bankruptcy Code and then incorporating the MLCBI with some changes. Prior to this, Brazilian lacked a specific legal provision to deal with international insolvency. I think it's fair to say that the implementation process of the MLCBI was brought up to speed due to the COVID crisis, because the country and our legal system urged a legal update to encompass additional legal tools, such as the financing and legal tools to negotiate tax liabilities in the environment of the enterprise insolvency. So the need to adopt the model law applied in economically developed nations for international insolvency was also a primary reason behind the implementation of the MLCBI. So Brazilian legislators considered that regarding the adoption of the MLCBI, the innovations provide greater certainty to legal foreign investors in the cases of transnational companies, fostering the credit market and the entry of new companies into the Brazilian market. The lawmakers also considered the adoption of the MLCBI to be beneficial, as it regulates the bankruptcy and judicial recovery of companies with multiple operations in multiple countries. They were also of the view that, in addition to aiding corporate collaboration among judges, such norms reduce the chance of international fraud against creditors and protect the interests of domestic creditors in the face of foreign creditors.
Thank you, Guilherme. And controversies arose during the enactment process concerning the language of the law in alignment with the MLCBI. The initial draft faithfully reproduced the MLCBI, while the enacted second draft included changes to the text suggested by UNCITRAL. First, under the Brazilian enacted law, the public prosecutor assumes an active role in international insolvency cases. The public prosecutor shall be heard and will be able to submit motions and appeals, potentially causing procedural delays. This relative depart from the MLCBI aligns the MLCBI with the Brazilian legal system existing in practice, where the public prosecutor holds an active role in specific case scenarios. Second, under the Brazilian enacted law, the definition of foreign non-main proceeding is a foreign proceeding other than a foreign main proceeding taking place in a state where the debtor has an establishment or assets, adding the term assets in the definition. Third, when dealing with the relief that may be granted upon application for recognition of a foreign proceeding, the Brazilian enacted law excluded the MLCBI provision that expressly includes a power to stay execution against the debtor assets. However, that does not mean that Brazilian courts cannot stay proceedings. On the contrary, the Brazilian enacted law grants the judge authority to grant the necessary relief. Further, there are articles in the Brazilian enacted law applicable only to liquidation proceedings, which do not find parallel in the MLCBI. These articles were drafted in 2013 during the discussion of another bill and were supposedly inspired by the EU regulations. In these articles, the Brazilian enacted law specifies that the main proceeding may be concluded only after the closure of non-main proceedings or when no remaining liquid assets exist in the non-main proceedings. Additionally, it stipulates that in the foreign proceeding, whether main or non-main proceeding, no assets, property, or remaining resource from the liquidation shall be delivered to the debtor if there is still unsatisfied debt in any other transnational bankruptcy proceeding. It lays down a list of mandatory information the judge of the foreign non-main proceeding must provide for the authorities of the main proceeding.
And turning to Singapore, Singapore strives to become a debt restructuring hub in the region, and the adoption of the MLCBI, amongst other major enhancements to its restructuring and insolvency regime in 2017, are key steps towards that goal. Singapore has been developing its case law on cross-border insolvency, with the highest court in Singapore, the Court of Appeal, giving its first reported decision on Singapore's MLCBI in 2021. In that case, the Court of Appeal had the opportunity to consider the issue and recognition of foreign proceedings, and when local proceedings should be stayed in favor of foreign proceedings. And just recently in 2024, the Court of Appeal held that foreign liquidation proceedings involving solvent companies are within the scope of Singapore's MLCBI. The Singapore case law demonstrates the court's approach to questions of cross-border insolvency is to assure an orderly restructuring or liquidation that's consistent across the various jurisdictions involved. When considering issues arising from the application of Singapore's adaptation of the MLCBI, Singapore courts would generally take into account 1. Any modifications which Parliament made to the MLCBI when enacting it as the Singapore MLCBI, and Parliament's intent in making any such modifications. 2. The approaches adopted by jurisdictions when interpreting the MLCBI or the corresponding provisions in those jurisdictions. And 3. The broader practical implications that would follow. Singapore made variations to the language of the MLCBI when enacting it as part of its local legislation in 2017. For example, under the MLCBI, the court can deny recognition only if recognition is manifestly contrary to public policy. Singapore's adaptation of the MLCBI, however, omits the word manifestly. This issue on public policy arguments came before the Singapore High Court in 2018 and recently again before the Singapore International Commercial Court in 2024. The latest decision departed from the earlier decision, where the Singapore High Court reasoned that the omission must have been deliberate and conscious, meaning the standard of exclusion on public policy grounds was lower in Singapore than in jurisdictions that had adopted the MLCBI's precise wording. The Singapore International Commercial Court in its 2024 decision, however, considered that the threshold for breach of public policy in Singapore remains high, even if the legislature omitted the word manifestly in its legislation. They also found there was an interpretive trend among various foreign jurisdictions to recognize that the public policy exemption in the MLCBI should be applied restrictively, and suggested Singapore's Parliament perhaps did not think it was necessary to include the word manifestly in the equivalent part of the legislation.
The courts play an integral part in the interpretation and application of the MLCBI as adopted in a particular jurisdiction, especially where the local jurisdiction has departed from the language of the MLCBI. Guilherme, as a practitioner, can you comment on the application of the MLCBI in Brazil?
So, Sabrina, I think the application of the enacted law in Brazil remains uncertain, especially concerning key concepts such as COMI and public policy, which is the first MLCBI video in this series discusses. So far, our case law has demonstrated the willingness of our courts to cooperate with foreign authorities. However, I must say that the few decisions reveal certain challenges in assessing the COMI and the recognition of insolvencies of natural persons. For instance, despite adopting the COMI concept in cross-border matters, the Brazilian bankruptcy law still provides in its general provisions that the jurisdictions is the venue of the place where the debtor has its main establishment. And regarding foreign companies with headquarters outside Brazil but operate here, conducting operations within the country, the local jurisdiction is established based on the location of the Brazilian branch. In these cases, to me, it's still uncertain whether the Brazilian courts will adhere to the MLCBI provision as to coming presumption, or whether they may be tempted to follow approaches divergent to the MLCBI. Also, Brazil has adopted a rule to punish forum shopping. However, the solution was ill-designed to prevent fraudulent or abuse forum shopping. The rule only provides that the foreign proceeding will be recognized as a foreign non-main proceeding if the coming has been transferred or otherwise manipulated. However, it does not indicate what are the suspicious time limits prior to the relocation of the office. Also, the use of a recognition as a foreign non-main proceeding as a tool to prevent forum shopping is ineffective, since the reliefs available to non-main proceeding, as we all know, are basically the same to those which might be granted to a foreign main proceeding. Moreover, there are concerns with Brazil's passive interpretation of public policy, especially regarding labor rights and jurisdiction, which may conflict to the narrower interpretation required by Article 6 of the MLCBI. In any case, I think the overall picture is favorable. Most of the Brazilian state capitals already have courts specializing in insolvency matter. There's a current trend to create more of those courts, therefore providing more legal certainty that the MLCBI principles will be applied in Brazil. And another important factor is that Brazil has joined the Judicial Insolvency Network, JIN, and formally implemented the JIN guidelines. And well, furthermore, although a slightly deviation from the language of Article 8 of MLCBI, the Brazilian law stresses that in interpreting the provision of this chapter, that is the chapter that deals with international insolvency, consideration should be given to its goal of interpretation, cooperation, and the need for uniform application and the observance of good faith. Therefore, it is expected that the UNCITRAL recommendations and principles will be applied in Brazil following the implementation of the model law.
Guilherme is referring to important resources made available online by UNCITRAL. These include the UNCITRAL Guide to Enactment and Interpretation, as well as other materials, such as the Legislative Guide on Insolvency Law, the UNCITRAL Practice Guide on Cross-Border Insolvency Cooperation, and the Digest of Case Law on the Model Law. Judge Fatima, has the MLCBI come before Bahrain courts for consideration?
Since the adoption of the model law in our law is relatively new, courts' utilization of the modern law on cross-border insolvency is yet to be tested. However, measures have been taken to ensure the proper application by way of dedicated specialized bankruptcy courts, specialized training opportunities for judges, trustees, lawyers, throughout workshops, roundtables, discussions, and more, peer-to-peer learning, including mentoring opportunities, adopting the JIN guidelines. So in June 2023, the Supreme Judicial Council in Bahrain announced the adoption of the guidelines issued by the Judicial Insolvency Network, JIN, regarding communications and cooperation between courts in matters related to cross-border insolvency. The aim of which was to enhance the mechanisms for coordination and cooperation between the bankruptcy courts in Bahrain and other judicial bodies at the international level in matters relating to cross-border insolvency, as well as to enhance the coordination with foreign insolvency representatives and other parties involved in cross-border insolvency proceedings, including holding joint hearings. Therefore, the JIN guidelines, being widely recognized worldwide, drew the roadmap to a better and easier communication between our national bankruptcy court and the bankruptcy courts elsewhere. In addition, we're working on having bench books, guidebooks for judges, litigants, and trustees So furthermore, we are working now on a number of guidebooks for judges, litigants, trustees, addressing the bankruptcy procedures and adopting the JIN modalities, which are designed to establish an administrative framework within which the JIN guidelines will operate, and laying out the mechanisms for initiating, receiving, and engaging in communication with other courts.
And in addition to the JIN guidelines, there is also the ALI-III Global Principles for Cooperation in International Insolvency Cases 2012. This is the result of a joint study commissioned by the American Law Institute and the III. These guidelines contain principles for cooperation and guidelines for court-to-court communications in international insolvency cases, drafted in a manner to be used both in civil law and common law jurisdictions. Yanis, turning to Greece, could you share with us the approach the courts have taken in applying the MLCBI?
Overall, the application of the MLCBI has not encountered severe problems in Greece, nor has it led to particularly big controversies. Once again, one has to look at the experience that has been gained in the EU context, in the context of the EU regulation, to understand how Greek courts have managed to address the challenges associated with the MLCBI framework, especially on matters relating to recognition. So, for instance, the question of recognition is usually addressed in a rather straightforward manner. This has been aided by the fact that the Greek legal framework was already familiar with the concept of COMI, which had first been introduced by the earlier version of the European Insolvency Regulation. In addition, COMI had already been, since the introduction of the Insolvency Code back in 2007, the jurisdictional standard to determine insolvency jurisdiction in the domestic context. And as a result, Greek courts have frequently encountered the question of its identification when dealing with insolvencies of shipping companies, which are usually registered in offshore jurisdictions but managed and administered through an office located in Greece. In that sense, I would say that Greek courts were already very well versed with the controversy surrounding COMI and had no trouble addressing them. The issue of post-recognition relief has also been relatively unproblematic, to the extent that the relief requested by foreign insolvency practitioners has fallen within the scope of one of the enumerated examples of what is Article 21 of the MLCBI. Greek courts have been rather willing and amenable to granting the requested relief. Now, the question of any additional relief, as far as that particular version of relief is concerned, Greek courts have also exhibited a practical approach. And a recent case from the First Instance Court of Athens really demonstrates the point. In the context of a Florida bankruptcy of an individual debtor, the U.S. Bankruptcy Court had issued a series of U.S. judgments that ordered the avoidance of certain antecedent transactions whereby the debtor had transferred real estate located in Greece to some of its family members. When the U.S. proceeding was recognized in Greece as a foreign main proceeding under the MLCBI, the U.S. trustee applied to the Greek court to request that the judgments be recognized and enforced in Greece against the beneficiaries of the unlawful dispositions in the form of additional relief under the provisions of MLCBI, or alternatively, under the Greek rules of judgment recognition. As you probably know, the question of whether judgment recognition can be pursued under the provisions of the MLCBI on relief is a highly contested matter. Nevertheless, in that case, the Greek court concluded that whereas the MLCBI does not include specific provisions on judgment recognition, it would grant the requested relief by referring to Greek judgment recognition rules. Under these rules, the recognition and enforcement of a foreign judgment was possible as long as the foreign court had applied the correct substantive law to the dispute, according to Greek choice of law rules, and had jurisdiction according to such applicable law. Considering that the U.S. Bankruptcy Court had jurisdiction and had correctly applied U.S. bankruptcy law to the avoidance issue, the judgments were capable of recognition and enforcement and were actually recognized and subsequently enforced. I think this case demonstrates that courts have generally tried to find a practical way to address the challenges and problems that are presented in the cross-border insolvency context, and have tried to interpret the MLCBI in a way that is consonant with the overall legal framework.
Thanks, Yanis. And we have also a similar experience in Singapore, where the High Court had in 2022 granted recognition and enforcement of a Chapter 11 plan and confirmation order as appropriate additional relief, in addition to recognizing the Chapter 11 proceedings pursuant to the MLCBI. And more recently, in 2024, the Singapore International Commercial Court also granted recognition and enforcement of an Indonesian composition plan pursuant to the MLCBI. As Yanis had mentioned, this is, however, not the same approach that might be taken in all of the jurisdictions which have adopted model law, with some jurisdictions taking the position that the MLCBI is limited to the procedural aspects of cross-border insolvency and does not govern choice of law rules to enable the enforcement of insolvency-related judgments. The inconsistent approaches to the interpretation of the MLCBI concerning insolvency-related judgments and the resulting impact on achieving the consistent, predictable, cross-border insolvency framework intended by a policy of modified universalism, therefore led UNCITRAL to adopt the UNCITRAL model law on the recognition and enforcement of insolvency-related judgments in July 2018 as a framework for uniform recognition and enforcement of judgments arising from insolvency proceedings.
I think that, if I may take a cue, the Greek experience shows that the existence of a modern and comprehensive regional framework for cross-border insolvency, such as the EU regulation, does neither preclude nor does it make redundant the introduction of the MLCBI. The MLCBI is valuable not only because it applies to cases that may fall outside of existing regional frameworks, but also because its implementation and application may be assisted by experience gained by courts, lawyers, practitioners in tackling similar issues that have been raised in the context of an existing regional framework. As a result, I believe there is significant added value in introducing the MLCBI, even when a well-functioning regional framework is already in place.
I would add, Yanis, that the MLCBI is even more valuable when there is no cross-border framework already in place, as it plays an important role in facilitating recognition, cooperation, and coordination, and it helps to avoid the multiplicity of proceedings in different jurisdictions, creating certainty, even where there may be departures from the language of the model law, as the case of Brazil, depending on each legal context, the UNCITRAL materials and approaches taken by the court in other jurisdictions in interpreting their version of the MLCBI may provide guidance in addition to the local courts interpreting legislatures' intent in enacting the MLCBI worded in a particular matter.
Thanks, Guilherme. And this concludes our segment on recent experiences in implementing the MLCBI. If you have any questions, please feel free to contact the members of our committee, and we will be more than happy to share with you in greater detail the experience of implementing the MLCBI in our respective jurisdictions. Thank you for watching. Stay tuned for the next video in our series on the legislative process on adopting the MLCBI.